How and when real estate contracts come to an end. In the earlier sections of this chapter, you saw how contracts are created, classified, and made legally valid. Now you turn to the last stage of the life cycle, how contracts end. In real estate practice, contracts rarely just fade away. They end in specific ways, each with specific consequences. A contract might end because everyone did exactly what they promised, because performance became impossible, because the parties mutually agreed to walk away, or because someone breached and the other party chose a legal remedy. As an Arizona licensee, you also have to factor in cure periods, statutory rescission rights, tail clauses, and Arizona Association of Realtors, AAR, forms that spell out exactly what happens when things go wrong. Understanding these forms of termination is critical. It affects whether your client can cancel, whether earnest money is forfeited or refunded, whether the other party can be forced to close, and when the broker still earns a commission even after a listing is canceled. Termination by performance. The cleanest and most common way a contract ends is through performance. When both parties fully complete their obligations as stated in the agreement, the contract is discharged. A purchase contract ends when the buyer pays the purchase price, the seller delivers a deed, and closing occurs. A lease ends when the term expires, rent has been paid, and possession returns to the landlord. At that point, the contract is executed, and no one has any remaining duties under that agreement. Sometimes performance is not perfect, but still good enough to terminate the contract. The law recognizes full performance, where all major terms are met. Partial performance, if both parties agree that partial performance will satisfy the contract and they release each other from further obligations. Substantial or sufficient performance, where a court decides that the essential purposes of the contract have been met even if minor details were not strictly satisfied. In real estate, substantial performance might occur when a seller completes almost all agreed repairs before closing, leaving only small, non-material items. If a dispute arises, a court might conclude the seller substantially performed and that the buyer's remedy is a small adjustment or damages, not cancellation. Arizona examples illustrate what happens when performance does not occur. If a seller cannot close because they lack funds to move out, that does not automatically terminate the contract. The buyer would issue a cure period notice under the AAR contract. If the seller still does not close, the buyer can choose among several performance-related remedies. Cancel and claim the earnest money as damages. Sue for monetary damages, such as the extra cost of buying a similar home later. Or file a lawsuit for specific performance to force the seller to close and record a lies pendens to cloud title until the case is resolved. If the seller does close but refuses to move out, the buyer may serve a 5-day notice to vacate and then file a forcible detainer action in justice court. The sale contract has technically been performed as to title transfer, but the seller's failure to surrender possession triggers another legal process to enforce performance of the obligation to vacate. Termination by impossibility or infeasibility. Sometimes a contract cannot be completed because circumstances change in a way that makes performance impossible or fundamentally infeasible. In general contract law, this is called impossibility or impracticability of performance. Suppose a contractor breaks his leg and cannot physically complete a painting job. If the contract was for his personal services, he may be excused, and the homeowner is free to hire someone else. Courts typically ask whether an unexpected event occurred after the contract was formed, whether it was beyond the parties' control, and whether it truly prevents performance, rather than just making it more expensive or inconvenient. In Arizona real estate, the death of a party shows how impossibility interacts with contract obligations. As a general rule, real estate contracts are not automatically canceled by the death of a buyer or seller. The decedent's estate steps into their shoes and remains obligated to perform, unless the contract is a personal services agreement, such as a listing. In one Arizona scenario, a buyer died the day before closing. The lender withdrew loan approval. Because financing was a contingency and the buyer no longer qualified, the buyer's estate was entitled to recover the earnest money. The contract itself did not terminate just because of death, but performance became infeasible when the financing contingency failed. In other situations, a contract may expressly address what happens if performance becomes impossible. A builder's contract might state that if government action prohibits construction, the parties may cancel. A land sale contract might condition performance on the buyer obtaining zoning or permits. When those contingencies fail without fault, the contract terminates without breach. Termination by mutual agreement and novation parties, who freely enter into a contract, can also mutually agree to terminate it. This can be as simple as a written cancellation, signed by both parties, or as detailed as a settlement agreement that resolves disputes and releases claims. Termination by mutual agreement is sometimes called rescission by consent or renunciation. If the parties simultaneously replace the old contract with a new one, that is called novation. For example, if a buyer and seller cancel an original purchase contract and immediately sign a new contract for a different price and closing date, they have discharged the first contract by novation. The new contract must meet all the usual validity requirements: competent parties, mutual consent, consideration, lawful purpose, and any required writing for enforceability. Mutual termination does not always erase a broker's right to compensation. Consider an Arizona listing agreement with a 6-month term and a 90-day protection or tail clause. During the listing, the broker shows the home to a buyer. Later, the seller becomes upset and demands cancellation. The broker, not wanting to continue with an unhappy client, signs a mutual cancellation. 3 days later, the seller contracts directly with that same buyer and closes. Even though the listing was canceled, the tail clause can protect the broker's right to a commission on that sale because the broker was the procuring cause of the buyer. In Arizona practice, termination, expiration, and cancellation of the listing are treated similarly in analyzing whether the protection period applies. Cooling off and statutory rescission rights. Rescission is the act of undoing a contract and restoring the parties, as much as possible, to their pre-contract positions. Sometimes rescission is based on misconduct, such as fraud or misrepresentation. In other situations, the law grants a statutory cooling-off period, where a party may rescind without any reason at all. Land sales in resort or subdivision developments illustrate this concept. A buyer may sign a purchase contract at a high-pressure sales event and pay a deposit on a vacant lot. State law may give that buyer a set number of days after signing to review the documents at home and rescind the contract simply by mailing a cancellation notice. This cooling-off period recognizes that consumers can be influenced by strong sales tactics and need time to reconsider. Arizona law also provides specific rescission rights in certain situations, such as subdivision lot sales. For example, a buyer who did not inspect an unimproved subdivision lot before signing may have a statutory period, such as 6 months, after contract execution to inspect and rescind. However, that extended right does not apply to improved homes. In one Arizona case, a buyer purchased a home based on internet photos, obtained inspections during the 10-day inspection period, but did not personally visit the home until 2 months after closing. The buyer disliked the property and sought to rescind, claiming they had a 6-month right. The answer was no. Purchasers of improved homes do not have such an extended statutory rescission period. Once the inspection period passed and closing occurred, the buyer could not unwind the transaction simply because they were unhappy. Courts also allow rescission where the identity of the actual buyer was deliberately concealed. In a frequently cited example, a seller was in a bitter dispute with a neighbor and chose to sell specifically to escape the neighborhood. The neighbor's son wanted the home, but knew the seller would refuse, so he used a straw buyer to sign the purchase contract, planning to take an assignment in escrow. When the seller learned the true identity of the buyer, the seller had the right to rescind. If the seller would not have signed had they known the real purchaser, concealment of identity allows rescission to protect the seller's freedom of choice. Revocation and unilateral cancellation. Revocation is an attempt by one party to cancel a contract without the other party's agreement. Technically, anyone has the power to revoke, but they may not have the legal right to do so without consequences. A seller can revoke a listing and ask the broker to stop marketing the property. A buyer can announce they are backing out of a purchase contract. But unless there is a contractual or legal basis to revoke, these unilateral actions may amount to breach. For example, if a seller revokes a listing without cause after the broker has spent significant time and money marketing the property, the seller may be liable for expenses or even a commission if the broker had already procured a ready, willing, and able buyer on the listing terms. Similarly, a buyer who walks away after all contingencies have been satisfied may forfeit their earnest money and still be exposed to a lawsuit for damages or specific performance. The key distinction is between revoking an offer, which is allowed any time before acceptance, unless an option has been granted, and attempting to revoke an already formed contract, which generally requires legal grounds or mutual agreement. Abandonment and lapse of time. Abandonment occurs when the parties fail to perform their obligations and effectively walk away from the contract without formal cancellation. Over time, neither side acts, no cure notice is sent, and the relationship simply dies off in practice. In some situations, the law will treat the contract as effectively abandoned, especially if a party has given the other side notice and an opportunity to perform, such as a cure period under the AAR contract. However, relying on abandonment can be risky because it is less clear than a formal cancellation. Arizona contracts often require a non-performing party to be cured before any further action is taken. For example, if a buyer misses a deadline, the seller typically must send a cure period notice. If the buyer still does not perform within the cure period, the seller can then cancel or seek other remedies. Without that notice, it may be harder to argue that the buyer abandoned the contract. Lapse of time is more straightforward. Many contracts contain an explicit expiration date or time. A listing agreement expires at midnight on its end date, if not renewed. An offer with a stated deadline expires automatically when that time passes without acceptance. A buyer's inspection period expires on the last day specified in the contract. After that, the buyer no longer has the same right to cancel based on disapproved items, unless another clause applies. When a contract or offer expires according to its own terms, the parties are no longer bound by its unperformed obligations. Invalidity, void, and voidable contracts. If a contract is void, it is treated as if it never existed. It has no legal effect, and no action is needed to terminate it. A contract to perform an illegal act or a contract missing an essential element, such as consideration, is void. Because a void contract is never valid, neither party can enforce it, and no one needs to cancel it. Voidable contracts are different. A voidable contract is valid and enforceable unless and until the party with the right to disaffirm takes action to rescind. Grounds for voidability include fraud, duress, misrepresentation, undue influence, or lack of capacity. If a buyer was induced to sign through fraud, the buyer may choose to rescind. If the buyer chooses instead to perform with full knowledge of the facts, the contract may become fully valid. Voidable contracts can be terminated by operation of law, such as when a court declares an agreement unenforceable, or by timely rescission by the injured party. The statute of limitations and the doctrine of laches limit how long a party can wait before seeking to disaffirm. Breach of contract and cure periods. A breach of contract, also called default, occurs when a party fails to perform according to the agreement. In Arizona's standard purchase contract, a party is typically not treated as in default until they have failed to cure within the cure period after receiving a cure period notice. This is why practitioners often say, in practical terms, that no one is in breach until they have been cured and still failed to perform. Once a cure notice is properly delivered, the breaching party has a set number of days to fix the problem. It is the date of delivery, not the date on the notice, that starts the clock. In one Arizona example, a seller signed a cure notice on May 31st, but intentionally held it for several days, hoping the buyer would perform voluntarily. When performance still did not occur, the seller delivered the notice on June 4th. The buyer argued that the notice was invalid because it was dated earlier. That argument failed. The cure period began on the date it was delivered, not the date it was signed. If the party still fails to cure, the non-breaching party gains access to remedies that may include cancellation and forfeiture of earnest money, damages, or specific performance, depending on the contract and the circumstances. Remedies: rescission, forfeiture, damages, and specific performance. When a breach occurs, the damaged party usually has a menu of remedies, not just one option. Rescission cancels the contract and attempts to restore the parties to their pre-contract positions. In real estate sales, this generally means returning earnest money and undoing any transfer, if the breach is significant and rescission is still practical. Arizona buyers sometimes seek rescission when serious undisclosed defects are discovered or when the seller's fraud is proven. However, as noted earlier, there is no general 6-month right to rescind a home purchase merely because the buyer later dislikes the property. Forfeiture forces the defaulting party to give up something of value under the contract. In real estate, this often means loss of the earnest money deposit. Many AAR purchase contracts treat the earnest money as liquidated damages for a buyer's default, provided the amount is reasonable. In one example, a buyer agreed to purchase a home for $100,000 with $5,000 in earnest money, but later refused to close. The seller canceled properly and immediately resold the home to another buyer for $120,000, making more than originally expected. The first buyer argued that the seller suffered no actual damage and demanded the earnest money back. The contract, however, stated that the earnest money was a reasonable estimate of damages because actual damages would be difficult to measure. The seller was entitled to keep the $5,000 even though the ultimate sale produced a higher price. If the earnest deposit had been unreasonably large, such as $50,000 on a $100,000 purchase, a court might treat it as an unenforceable penalty rather than valid liquidated damages. Damages are monetary compensation awarded by a court for actual loss. If the contract specifies the amount or formula for damages in the event of breach, they are called liquidated damages. If not, the plaintiff proves the amount in court and the award is unliquidated damages. In Arizona, a buyer whose seller refuses to close might seek damages equal to the increased cost of buying a comparable property in a rising market, plus incidental expenses. A seller whose buyer defaults might claim carrying costs, lost opportunities, or price reductions needed to resell. Specific performance is a special remedy in real estate because land is considered unique. Courts are more willing to order specific performance for contracts involving real property than for ordinary goods. If a seller simply changes their mind and refuses to sell after signing a purchase contract, the buyer can often sue for specific performance, asking the court to order the seller to convey the property as agreed. The buyer may simultaneously record a lis pendens against the property, warning potential purchasers and lenders that the title is subject to litigation. This often pressures the seller to perform or negotiate a settlement. Likewise, in some circumstances, a seller may seek specific performance against a buyer who refuses to close. The choice of remedy is strategic. A buyer might prefer the certainty and speed of earnest money forfeiture and cancellation rather than years of litigation seeking specific performance. A seller might choose damages or forfeiture, rather than forcing an unwilling buyer into ownership. As a licensee, your role is not to give legal advice, but to understand the range of possibilities well enough to spot issues, guide clients to seek counsel, and structure contracts in ways that clearly define remedies. Review summary. In this section, you learn that contracts can end in many ways, and each path to termination carries different consequences. The simplest and most desirable termination is performance. Both parties fulfill their promises, and the contract ends naturally. Where performance becomes impossible or fundamentally infeasible due to events beyond the parties' control, the doctrine of impossibility may discharge obligations, as long as the event truly prevents performance and was not caused by either party. Parties can also terminate by mutual agreement, sometimes replacing the old contract with a new one in a novation. Tail clauses in Arizona listings can preserve a broker's right to a commission even after mutual cancellation if a buyer procured during the listing later closes. Statutory rescission rights create cooling-off periods for certain land sales and protect sellers against concealed identities. Unilateral revocation of an existing contract, however, usually amounts to breach unless justified by law or contract. Abandonment and lapse of time are additional, though less precise, routes to termination. Failure to perform with no cure and no activity may lead to practical abandonment, while explicit expiration dates cause contracts and offers to end automatically. Void contracts terminate without any action because they were never valid, while voidable contracts can be rescinded by the injured party within time limits. Finally, you examined remedies when termination results from breach, rescission, forfeiture, often of earnest money, damages, liquidated or unliquidated, and specific performance. Arizona examples involving cure notices, earnest money forfeiture, sellers refusing to close, post-closing holdovers, and subdivision rescission rights anchored these concepts in real-world practice. Together, these rules give you a practical framework to understand what happens when a real estate contract does not go according to plan, and how Arizona law shapes the outcome.